does not, you don't control the technology. Okay. Not yet. Those are due the last day of classes, right?
Wow, Zoom is really asking a lot of questions today,
I'll check.
or Facebook is.
Just really want to make sure you know what you're doing.
Somebody's got some music playing in the background. Content is not available right now.
Okay.
Go to newsfeed.
I thought there was one that I missed.
So we're having technical difficulties with Facebook, Sarah.
Oh, well, I've got the recording at least, so I can post the link to our YouTube video.
Okay.
Taisha, are you seeing it on Facebook at all? Oh, no, there it is. Looks like it's there. Great. That's fantastic. All righty. Taisha, should I give it another minute or do you think we should get started?
Yep. That is acceptable. That's great. Okay. You good? Yep. Why?
I'm sorry, I was on mute. I think you're all,
We're all ready?
I think so. Sorry about that.
Oh, that's okay. I was just giving my son a heads up that the camera was on. So, okay, well, welcome everybody. I'm sure some people will continue to log on as we move forward, but thank you for attending our May Onondaga County Cash Coalition Financial Friday series. Today we are talking about the all-important topic of rent relief. We've been waiting for this for a while. We are pleased that Onondaga County is doing a lot of work to push out the information about rent relief. And we have two guest speakers with us today. I'll give them introductions in a moment to tell us how to access those rent relief funds. And so you can either help your friends and neighbors or go ahead and apply yourself. My name is Andrea Wandersee. I'm the Executive Director of NEDA, the Northeast Holly Development Association. We do housing, small business support, and community development work on the north side of Syracuse. I'd like to give a thank you to my colleague, Taisha Martin. She's the director of our housing program and helped set this program up today. And she's a great resource for people as well. And I just hit the wrong button. I scrolled through you guys instead of the slideshow. So just a few housekeeping details. You are welcome to use the chat room or Facebook comments to submit questions or comments. Welcome to keep your video on and participate in the presentation. And there will be a deadline for questions and answers. There's a couple people I'm just going to mute. And if you need to get on, you can send us a message if you're having difficulty. Okay. Sarah, if you can keep track of some of that background noise and maybe mute people if there's some background noise, please. So the Onondaga Cash Coalition is a wonderful group of people who work on financial health for our community. CASH stands for Creating Assets, Savings, and Hope. It's a coalition of local organizations dedicated to promoting financial stability and asset building opportunities for low to moderate income families and individuals in Onondaga County. Here is a list of the organizations that are involved in the CASH Coalition. The United Way is a big sponsor of the program. The Syracuse Financial Empowerment Centers, which we'll tell you about at the end of the program, and a variety of other agencies, financial agencies, educational and service agencies. And Anita's really proud to be a part of this group. So we're going to kick off our presentation with Megan Stewart. Megan's the director of the Housing and Homeless Coalition of Central New York, which is HUD's continuum of care for homelessness.
Okay.
The coalition's mission, I'm sorry, Megan, I had to, they've got a little bit more. The coalition's mission is to assess community needs and foster collaboration in an effort to prevent, reduce, and ultimately end homelessness. She's been serving as the director since June of 2018, and prior to that was the performance specialist at the Housing and Homeless Coalition. She's worked in housing and homelessness for over 10 years, overseeing federal, state, and locally funded projects. She holds a bachelor's degree in anthropology and sociology and political science from Morehead College, and an executive master's in public administration from Syracuse University. Megan, thank you so much for joining us today. And I'm going to hand it over to you.
Sure, thanks, Andrea. Great, so I'm going to walk people through the county's rent relief funds, what they are, who's eligible, and then we're going to take a look at the website on how to apply and walk through some of it. It'd be challenging to walk through the whole thing, but we'll give you some important tips on navigating the rent relief website. So I'll start with what are rent relief funds. So these funds were provided by the Department of the Treasury through the American Recovery Act, and the allocation was directly given to Onondaga County for rental arrears and rent. Onondaga County received a historical $24.5 million in funding for rent relief locally. 10% of that is administrative funding on getting this program running in the community, building the website, partnering with local organizations to help people qualify and fill out the applications and things like that, which I'll get into a little bit more when we look at the website. And it covers up to 12 months of back rent, and that goes back to March of 2020. It really is COVID relief funding, so it doesn't cover any rent before the pandemic began in March of 2020, but it can also cover 3 months of prospective rent as well, or be used for utility arrears, again, in that same period of time, going back to March of 2020. Next slide. So who can apply? There are basically two groups of people who can apply for this rent relief, and those are tenants residing in Onondaga County, and then landlords on behalf of tenants who are residing in Onondaga County. But it is important to note that this is a tenant-based program, and the tenant has to meet the qualifications for the program in order for the landlord to apply on their behalf. So it's really about that tenant qualification rather than the landlord meeting any of the qualifications, or it's not landlord relief. It really is tenant relief funding, and that's an important notation. Next slide. So the eligibility, and I apologize, that median income box is pretty small down there, so bear with me. So tenants have to have an obligation to pay rental arrears. So what that means is they have to have some form of legal tenancy. It couldn't be you're staying with a family member and they've asked you to pay $500 to stay there. It really has to be rent that you're legally obligated to owe. They have to have been at risk of experiencing homelessness or housing instability, and that's could be a number of things: being rent burdened, being low income, having been homeless previously, and there are some questions in the online portal that ask about these things. There has to be a financial hardship reason due to COVID that you need these rental assistance funds. So you'd have to prove a reduction of income or other financial hardship like increased costs, caretaking, things like that. There is an option to do a self-attestation for that, but you do have to prove some form of financial hardship. And then the last is that you must be 80% or below the area median income, which again is that tiny box down there that you can see for a single individual. You can't make more than $44,550 a year. For a family of four, it's $63,600 per year. And then important to know too is that there are targeted prioritization groups within that. So they will be prioritizing families who are at 50% or below area median income. And I obviously couldn't fit that on the slide. So the really very low income families will be prioritized for assistance. And next slide, I think we're going to the website. Okay, so this is the website, very easy, ongovRentHelp.com. If we can click on that, we'll show you at least the first couple parts of it and some important information. I don't know, Andrea, if you're only sharing the PowerPoint. Oh, you're muted. There we go.
Is that better? Sorry.
Yep, we can see it. I figured you were sharing the PowerPoint.
But I didn't change the share screen piece. Sorry about that.
No problem. Yeah, so this is the landing page for the rent relief funding. Obviously, there's a big apply now button that you can hit to apply for funds. But before we do that, I'm going to have Andrea, if you can just scroll down a little bit. So those main 4 qualifiers are right here on the landing page. People can look at before they hit apply. Now, again, there's plenty of opportunities to hit apply on this website. So if you miss one while you're scrolling, there are many more. If you want to scroll down a little bit more, there are some find out if you qualify. Again, you can apply here. You can learn more. There is a phone number if people need assistance filling out the application, and that is right here for people to call. And then scroll down a little bit more. And I had mentioned before that there are a number of organizations partnering with the county to help people complete applications. So this is the list of those organizations. They're all over the city. Many different types of organizations, which is great, have signed on to be partners to help people apply for this. And these are all linked to their websites and information. So if someone needs assistance, they can contact an organization maybe they have a relationship already or feel comfortable working with. And then down further, there's some additional resources, links, some paperwork you might need, frequently asked questions. And then below that, there is an ability to download a fact sheet in, I should have counted how many languages, but a number of languages. And I know these were the top spoken languages in Onondaga County. They made these fact sheets in, so you're able to download that in any of these languages.
It looks like there's 11 languages, including English.
Thank you for counting. I meant to do that. So this is great for if you're working with refugees or new Americans or anyone who English isn't their first language. That is right there, and you're able to have some accessible materials for it. So if we go back on the website, same information geared towards landlords. And I know Lori's probably got a lot to go through. So we'll hit apply now and just go through a couple of the first pages of the application that might be helpful for folks. So this is, again, just the landing page. If we want to hit next, I want to, okay, so this I think is probably the most important page for us to look at. So the rest of the application really looks like any other fill-in form that you'd see in a website application. But I think this is one of the most important aspects, because for those eligibility qualifications that I had mentioned, there are associated documents that tenants need to upload in order to receive assistance. If they're unable to upload documents, the organizations that are listed on that landing page are able to help with that, or folks can drop it off at the Civic Center. So there are options if people aren't able to scan and upload a document, but this is the list of required documentation. So if you have an unemployment award letter, a lease, a demand letter from the landlord for the rent, recent pay stubs, preferably ones that show if you had a reduction in hours or something like that. Tax returns if you're self-employed. Unemployment award letter is on here twice, or a Social Security award letter. If you are applying for utility assistance, you'll need that utility bill. If you are a landlord, you have to have a W-9 form, which is the tax form to receive payment from the county. And then if you're a landlord applying on behalf of a tenant, you need a release that you can release their information in order to receive assistance. If a tenant has an active temporary assistance or SNAP case, they can skip the documentation because the county will already have that on file and just fill out the application. I will say that if you're working with a tenant or you are a tenant and you're not sure if you qualify, or you aren't exactly sure what you would need to add in, contact those agencies, but go ahead and fill out the application and submit it. They will follow up with what they need from you, but it's safer to apply than to just not apply because you're not sure if you qualify. And I believe the rest of it, like I said, is a typical application. It'll stop us if we don't go through and hit all of them. So we'd have to make up a fake person to go through the whole process, which would be time consuming. And Lori's got a lot of great information she'd like to share too, but it'll go through like this and really prompt people on if they're the tenant, if they're the landlord, if they're the tenant or a subtenant. So if you currently reside where you owe, if it's located in Onondaga County, and are you a citizen of the United States?
Megan,
Yeah,
can non-citizens apply?
that is a great question. Let me see if that's on my fact sheet. I am not 100% positive on that, but while Lori's presenting, I'll look it up in the frequently asked questions.
That'd be great. Thank you.
Yep. And then, are you applying for help paying back rent? And are you applying for utilities as well? And you can apply for both. I don't know if I mentioned that. You can apply for rent and utilities. So these are the COVID hardship questions, and they are check marks. So you could have 2 of these be true or all of them be true. You qualified for unemployment, have seen reduction in income. If you do click like Andrea just did, the experience other financial hardship, they do ask you to describe what that hardship was. And then have you been employed in the last 90 days? And then I think that will bring us to, yep, okay. And this is where I think we'll stop because we don't want to go through and add fake information for someone. But from here, it's really demographic and getting the documents uploaded. So you can go through and submit after that. So with that, we're doing questions at the end. So I'll turn over to Lori and look up that citizen question.
Okay, Megan, thank you. And Andrea, if you wouldn't mind stopping sharing, that would be great. I can introduce myself. Most of you know me, I think, at least in this virtual world here. Hi. How is everyone holding up? Like, seriously, have these been crazy, crazy times, and the past week has been so tough for our office. We've gone from just morning hearings at court to morning and afternoon hearings at court. So please, number one thing, let people know that court's happening. So who the heck am I? My name's Lori. I am the program director of eviction defense for the Volunteer Lawyers Project of Onondaga County. Most people don't realize that a tenant facing the loss of their home has no right to have legal representation. There is no right to that. In New York City, they have some kind of universal representation that they've been trying to set up since July of 2017, but it's not like a criminal case. These are civil matters. And not only that, eviction cases are summary proceedings. That means they're super short. The rules of evidence are limited. Testifying is limited. Most people will get maybe 3 to 5 minutes in front of the judge if they're really lucky. And there's no guarantee that someone's going to get an attorney there. So through the work of Deb O'Shea from our office over a decade ago and lots of people and coordinating, we've set up a program where we have volunteer attorneys at court every single morning to help tenants in the city of Syracuse. We also work in the city of East Syracuse. Other agencies, if you have people outside the city of Syracuse, would be Legal Services of Central New York or Legal Aid of Mid-New York. Our office can provide advice and counsel, but we don't actually represent in those courts. And for private, non-subsidized, non-public housing tenants in the city of Syracuse, Hiscox Legal Aid Society also helps out. We are committed in Syracuse to safe and stable housing for residents, and it's unusual. It's not the typical situation for city courts. So that's one thing to know, that we are a resource, mainly grant funded from a lot of different organizations. And we're very, very thankful for the opportunity to help our tenants in this way. And we recognize how unusual it really is. So who's confused about what's happening in the world right now with regards to tenants, and who thinks that we have a moratorium in place? Have you all heard that we have a moratorium? Kind of, sort of. I wish that we could strike that word from our vocabulary, because it's in every article, right? You look at the news, it's moratorium this, moratorium this. 2 days ago, the CDC moratorium was struck down by a Washington, D.C. judge. Okay. There's no blanket moratorium. It's confusing to tenants, and they think they don't have to show up to court. Cases are still happening, and people are still getting warrants of eviction because they don't show up. And that's all they really need to do, is show up. So the first and most important thing to realize is that we don't really have a moratorium. We have defenses. We have extra defenses because of COVID that will apply to most tenants, at least the tenants that we see who have been experiencing poverty in the city of Syracuse. But let's go over what they are so that you have a better understanding, and that you can always email or call me, but you'll probably have to leave a message because I'm in a lot of meetings like this and in court a lot. But all my contact information is in the materials that'll be forwarded. And so to answer the questions from before, first of all, if you are helping someone to go through the application, or if you're not sure how to do it, DSS has told me that it is perfectly okay for you to practice and put test as both of the first and last name. So test for the first name, test for this, put in fake data and practice how this form works, because it's not super complicated, but it does require in certain places where you might have to upload documents and just get yourself familiar with it, but they can filter out test cases from what they've told me. So it's okay to practice, and undocumented residents can apply and are eligible. So that's just something to know there. The one thing that there are a few things that are going to be difficult with regards to tenants eligibility that everyone should really know is that if someone might apply. It doesn't hurt to apply. It's helpful to apply. Just make sure the information is truthful. Let them make the determination. The landlord has to cooperate. We're working on that behind the scenes, and I'll tell you a little more about that. Also, what makes me a little nervous is that lots of people lost jobs and income during COVID. They lost hours of employment, but maybe now we're back to employment, and eligibility, from my understanding, is going to be based on the income at the time of the application, not at the time when they might have had the job loss, even though 6 months ago things might have been in a really bad place for them. They may not be eligible now, but we're working on that. And I know that DSS is committed to helping as many people and as tenants as possible to remain stable. So let me briefly talk about, for 10 seconds, how evictions happen, because it's important to understand that evictions are not just because of non-payment. Evictions are primarily, normally, in regular times, 90% of them are for non-payment. People couldn't pay, didn't pay. They get their apartment repossessed just like they would a car. That's considered a summary proceeding. And the other 10 to 15% generally are called holdover petitions, where the landlord just has given someone notice. There are proper notices required. They are due processes required to tenants at all stages, but they've been given notice to leave and they haven't. They're called holding over for the time of their lease and or the time of their rental, and the landlords will bring a holdover petition. Because of the Emergency Eviction and Foreclosure Protection Act of 2020 that happened in December, the state legislature has developed new defenses available to tenants in both of these cases. And in order to qualify for that defense, a tenant has to submit a tenant hardship declaration form. There's no exception to that. They have to submit the actual paper form to their landlord or to the court to stop an eviction. The good thing, though, I mean, it's hard because there's paper, right? And it's hard for people sometimes to print things out or to access this form. But the good thing is that that form will help at every single stage of the eviction. So if it's truthful, and we're going to go over what truthful looks like and how this form works and how to access it, anyone can help a tenant get this form. And if it's truthful, it stops all proceedings in the case, no matter what stage they're at, until August 31st. This week was so crazy because it expired originally on May 1st, and the legislature didn't even vote until late Monday afternoon when it had already expired. The governor did not sign it until late on Tuesday. And we had people that were not our clients, but who had reached out to us, who had been served with an eviction warrant for those days and had no idea what to do. The defenses, we had somebody on Wednesday morning who was expecting to be evicted. So we submitted the form, and the landlord attorney freaked out. It's like, well, the governor hasn't signed it yet. I'm like, the governor's going to sign it, but not knowing whether he was going to be evicted on Wednesday was really awful. And so late on Tuesday, I got a glass of wine because the governor signed the form. Okay. So the form is not difficult, but I want to show you what it is. You may have already seen this before, but just to reiterate, anyone can get a copy of this to a tenant. If you get it to the landlord before, like say they're having issues and you give it to a landlord, they're not supposed to be allowed to file a case. They have to affirm to the court that they've given this to the tenant and haven't gotten one back. So they're lying if they if they've gotten one of these forms and we can prove that at court, this will be dismissed completely because they weren't supposed to have filed it. But if they bring it to court, if they bring it to the clerk, and we've asked the clerk's office to keep copies of these available at all times. So anyone who is facing an emergent eviction, or anyone you hear about, can go to the clerk's office at the city courthouse in room 130 and ask for a copy of the residential tenant hardship declaration form. And they've agreed to do this because when they mailed them out, the court actually had to mail these out to tenants. When they mailed them out, a huge percentage of people were actually mailed the wrong form. They were mailed the commercial tenant form instead of the residential one, and it's all different. So they've agreed to keep copies on hand at the clerk's office to help out any tenants. So if you know of someone who's been given a warrant of eviction by default, because they didn't show up to court, they didn't think they had to, they thought we had a moratorium. We see a lot of this right now. They can go to the clerk's office and stop it immediately. Like they can do it at any stage. They can hand a copy of the tenant declaration form to the marshal when the marshal comes to do the lockout and say, this is my magic piece of paper, you can't evict me. And the marshals are supposed to respect that by state law now. Okay, so that's why this form is so important. And I'm going to quickly show you all. It's available at nycourts.gov. It's also available. This is our website. You go to the part where it says get help, go down to renters' rights and CNY. And we're going to remove the CDC tenant declaration because I don't know what its effect is going to be in other parts of the country. In New York, it's irrelevant now. Okay, our laws provide for greater protection. So this tenant hardship form, you'll see we have it in many languages. We've done translations above and beyond what the court required as well. And there's also a little video at the bottom. It's not terribly long, and I hate making videos. I'm so sorry about the way I appear in videos, but it's there to explain it to anyone who has questions. This is the form. And remember when I said how many types of evictions are there? There are how many? 2, right? There's holdover and there's non-payment. There's also a really small proportion of cases generally that's considered a holdover and it's treated as a holdover, except it's alleging that the tenant engaged in objectionable behavior. Now, objectionable behavior hearings, we're going to see a lot more of them because the only exception to this tenant hardship form comes right here, where it says you may still be evicted for violating your lease by persistently and unreasonably engaging in behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others. These 4 lines here are what the next 3 months of my life are going to look like. It's going to be hearings about this because all other cases where there's a hardship form in place will be postponed, and landlords are going to be saying, the tenant had a big dog that attacked somebody, or I asked that. It's going to have to be a matter of hearing and of fact at the court. And it has to be persistently unreasonably engaging in behavior that harms other tenants, not just like the case I had yesterday where the landlord was like, oh, this guy's really annoying to me. No, it's not about the landlord, it's about the tenants. Okay, enough, off my soapbox. So this is the hardship form. If there is a case at court, and on our website, this is a PDF that's fillable. You can type in, whatever the case number is, and then the city and court. If you don't know it, leave it blank. Don't worry about it. The court will match it up by the person's name. Remember to fill out this line here. Okay, this is the address, and it's important to have the address so they know that matches up, and then click off A or B or both, and then sign at the bottom. It says you're signing and submitting this form under penalty of law, and it's against the law. It doesn't technically say perjury, but it does say it's against the law. Okay, what are the basis for this? This is affirming financial hardship due to COVID. So there are 5 statements under Part A, and any one of them can be a reason to check off box A. You don't have to say which one it is. So significant loss of income, increase of out-of-pocket expenses, childcare responsibilities, or that made it harder for me to earn income. Maybe you couldn't work as many hours because you had kids home from school. Moving expenses and difficulty I have securing alternative housing, make it a hardship to relocate. I think a lot of people are going to qualify for that one. Other circumstances affected my ability to maintain a meaningful employment. And then there's this other little statement that's to the extent I have lost household income or had increased expenses, anything that I received did not fully make up for that. Okay. So if you've got people who really legitimately were not paying their rent when they were making more money on unemployment, watch for that, because let's talk about the effect of all of that when I finish up with B. B is that vacating would cause a severe risk or a health risk because we're in a pandemic. It also says an agreement that you understand the rent is still due. No one has ever said that you don't have to pay the rent. Okay. So that they're not waiving rent for anybody. And that a landlord may still seek eviction. So if they're not waiving the rent, what does all of this mean, right? If they're not waiving the rent, this form is going to be considered like after August 31st. When we get through all of this, this form is going to be considered by the courts as a presumptive evidence that there has been financial hardship due to COVID. They are probably going to give landlords the opportunity to argue that and to prove it. And the new defenses include the Tenant Safe Harbor Act. To tie this all in, the Tenant Safe Harbor Act says that if someone's had financial hardship due to COVID, they can't be evicted for not paying their rent during that time. So that means that they can get a judgment against those tenants, but eviction is supposed to be removed as the remedy for the non-payment. When normally we'd said that non-payment evictions are the most common types. It's like a repossession. They've removed eviction as a remedy for non-payment if the tenant proves that the non-payment was because of a financial hardship due to COVID. Okay, so that's a lot. And remember that there are other ways that the landlords, I believe, are going to keep trying to evict people, either by alleging behavioral issues or by just saying, fine, you're not paying the rent, you're not working with me, I'm terminating your lease, and they will give a lease termination. And then it's up to the tenant to be able to prove that that's why the landlord did that, and to argue that it was done in retaliation when right now, there is no specific law that would say that type of retaliation isn't allowed. It's not very, very clear in any of the case law. The only retaliation that's specifically prohibited is for a tenant making complaints about housing quality. So, and that's presumed to be retaliatory for up to a year. So there's going to be a lot going on come beginning of August. And if people think, I mean, my advice to people is that we're in the summer, kids will be, we'll be in the summer soon, kids will be out of school. If a family feels that they are going to need to transition, this extra time is a free gift for them to go and try to make a transition to a new place and move. Housing, I know, the housing market is very, very tight right now, but come September, October, if evictions start happening after August 31st more, then I think the market could be even tighter then. It's really, or maybe it'll open up when people start moving around a little more. The idea though is they're not supposed to be evicting for non-payment if it was a financial hardship due to COVID, and they want the parties to try to work that out with the rental application and the relief application. But right now we are seeing a lot of court filings and people not showing up. That's why I put the court in the background here, because people just are not showing up and then getting in a warrant of eviction when they think we're in a moratorium and they may not be taking it seriously. So that's my message for the day. I know, thank you. That was a lot. I know and I talk really quickly. So if you have questions, you can always reach out and I'm happy to answer any other questions now. So thank you. Is there anything I didn't cover that you would like me to cover that you have questions about?
No, thank you very much, Lori. That was great. I'm going to turn it back over to Andrea to wrap things up and do Q&A.
Yeah, no, that was really helpful, Lori. I think the word moratorium is difficult and it makes it hard. I know there's a lot of service providers here on the call. It makes it hard for us to advise people about the best steps. But I think your point that, you know, they should fill out the rent relief application, and if they are expected in court, they should be in court, and ideally work through one of our terrific agencies to provide them some support, legal support. We do have a question in the chat. Is termination the same as non-renewal?
That's a really good question. So yes and no. So normally at the end of a lease, it would be extended unless the parties give each other proper notices that the lease is ending. And the notice that's required is dependent on how long someone has lived there. So if it's less than a year, it's 30 days. Everyone knows 30 days. But about a year ago, this all changed. If someone's lived there between a year and 2 years, a landlord has to give 60 days notice to terminate or to non-renew. And if they've been there over 2 years, then it's 90 days notice. And so a termination is a little different, because a non-renewal is like, okay, we're reaching the end of our term and I'm not going to renew that. And once a lease has ended officially, if a tenant keeps paying the rent, the tenancy continues on a month-to-month basis on the same terms as the regular lease. So it becomes a month-to-month tenancy, but again, those notice provisions are based on how long someone's been there. So a termination, so that's a non-renewal. A termination is kind of the same, but a little different. A landlord in the middle of a lease term could, based on claimed lease violations or objectionable behavior, or they're saying that the tenant has broken the lease by doing something that they weren't supposed to do, or by not upholding the lease terms. So they're considering that a termination. They're saying that this has been terminated, but they kind of use it interchangeably. But the effect would be, for one of them, it's a holdover case, and normally a landlord doesn't have to give a reason for not renewing. But for an objectionable tenancy, they have to prove that the tenant was given an opportunity to fix the problem or to cure. Say a landlord saying, hey, you have this big Doberman on the property, you're not supposed to have any pets, then they're supposed to give them an opportunity to fix that and to come into compliance before they bring a case. And there are different things of defense. Because we're in this weird time and we have this Emergency Eviction Prevention Act, the standards for objectionable tenancy are much harder for a landlord to prove. That's why I'm saying that those 4 lines are going to be the ones we're arguing about all summer, because that's the termination or the objectionable tenancy type case that is not protected by this Tenant Safe Harbor Act and by the tenant hardship declaration form. Is that too much or too little? Probably too much to get her to stop talking. Right? Does it make sense though?
I think so. Does that answer your question, Maggie? She says yes, it makes
Okay,
sense.
yes. Okay.
Taisha indicates, what happens if you have trouble securing documentation of a hardship when filing the application?
You don't need documentation to support the filing of the tenant hardship form that's on our website, or the one that you can bring to the courts. But if we get to August 31st and the case is put back on the calendar and it becomes a time and you haven't secured the rent relief. See, this time is so that people can get that rent relief together so that they can come up with a settlement agreement with their landlord. If you're going to have a rough time proving and helping us prove to the court that non-payment was because of a financial hardship due to COVID, then we should talk. We should figure out next steps, because that's what's required in order to avoid eviction in the fall when this is over. Right. So, but filing the form, you don't have to have the documentation, but you will if you want to assert those defenses later on.
And for the rent relief, there is a self-attestation option to prove hardship.
Megan, is there a draft of an attestation? I mean, I'm not sure everyone would know how to write something like that. Is there some place where we could go and say, oh, this is a sample statement that I can adapt to my situation?
That is a great question, and it's not in the additional resources link. So I can reach out to the county and see if they did have a draft. I know in the law that came out from the Treasury, there was something like that in there. So I don't know if the county then adopted. I don't want to say use the one from the Treasury, because if the county adopted something that they would prefer.
Yeah, because I think that would be great. Again, there's a lot of service providers here on the call, and if we had something to go to.
Also, we have found that there are times when we don't have the document right in hand, that when we're putting the application in, and so we can't upload it at the time that we're putting the application in. So we complete it anyway. You can, if you click on it one time, they'll give you a notice saying, hey, this is missing. But if you click on it again, it will allow you to proceed with the application. So you've got to do that twice. But if you can't get it in at the same time, there is an email in the frequently asked questions and also on their website where you can supplement. So you can attach documents to an email and send them in. Just make sure that the application number, once it's completed, is included in that email so they can match up the documents. And we've done that quite a bit. And so far haven't had any problems with that.
So I have a question, and I think I know the answer, but I want to make sure I'm correct. So there's a limit to how much rent relief someone might be able to get. So if I'm applying for rent relief, my rent might be higher than the actual relief package that's offered. Is that correct? And then my landlord has to accept, well, it doesn't have to. If my landlord accepts the rent relief, they are then subject to all of the rules, and they're saying, yes, I'll accept $800 a month instead of $1,000 a month, and we're going to be okay. Is that a correct scenario?
Yeah, so that is part of it, and they can't make a landlord accept anything. But then if they've turned it down, then they're not supposed to be able to evict for the non-payment because the payment was offered. The problem becomes when there's a partial payment. So a tenant can only be evicted for rent. They can't be evicted for extra fees, court costs, attorney's charges, anything else, just the rent. So that's the only basis for a non-payment eviction. And if not all of it is offered, then this becomes a settlement agreement. And this is something, thank you for bringing it up, Andrea, because there are landlords who are reluctant to participate. We've heard landlords who are just say that they're going to refuse to participate as a blanket thing because they think they're not, A, they think they're not going to get all the rent, but B, one of the requirements of accepting this money is that they agree that they will keep people in the apartments for at least a year afterwards, except that they can evict for non-payment or for good cause, like the objectionable tenancy, or because the landlord wants the property back for a reason where they want to move in. But otherwise, it's a requirement of a good cause eviction, and not just because the landlord gave a notice to non-renew or to terminate, because normally they don't need a reason. So because there's reluctance, there is a mediation program being set up through the courts and Access to Justice Committee and new justice mediation that DSS will help to and the courts are supposed to help refer tenants and landlords to the mediation program to help them understand the process and to understand what their rights are throughout, to overcome some of that. And I do a ton of that already. I'm talking to landlords saying, no, this is, if you're not giving up as much as you think. There's also a requirement though, that the property be part of the rental registry or be in compliance with codes. And we're seeing some reluctance about that too. But by law, if that's the case now, and this goes into like, there's so much of landlord tenant law, right? But right now, if a property is not in compliance with the rental registry in codes or has a certificate of occupancy for codes, then they're not supposed to legally be allowed to collect rent or to evict for non-payment of rent. So that's a defense that we need to know. We check codes for every case that comes through that we're representing at court. We look to see what the standards are. So it doesn't mean that people get to live without paying for use of the space. They can still get a judgment for what's called use and occupancy of the property. When there's no rental agreement in place, we don't call it rent. It's like the value of having a roof over your head is what the court will determine. And sometimes that's the same as rent, and sometimes it's a little different depending on conditions of the property. And that's a fairly new requirement in the city, especially with the rental registry. So when we get back to court regularly, I think we'll be litigating that a lot more. But we're also seeing a lot more properties being put on the rental registry and getting the inspections, which is great. The city's done a lot, I believe, to try to start enforcing housing quality issues a little more. They've got the new codes department being organized. They have the new Bureau of Administrative Adjudication that can actually fine landlords now. The codes department can hand out tickets. They are doing more internal inspections. Everyone's heard about Skyline and the horrible situation there, but they're not the only ones, frankly. And we've got a new task force within the city government that's combining lots of different departments where they're trying to make sure that these properties are safe for tenants and safe for our first responders. If the police or fire department have to go visit, we need to make sure that this is a city where people want to live and where we're maintaining good quality of standard for our apartments. And it's a multifaceted problem that requires a lot of different ways of approaching it. And I'm seeing more and more of that lately. I think it's only going to be for the better in the long run.
That's
like
great.
to yeah.
Really brought up the rental registry. My understanding is if somebody is not on the rental registry, they have a window of time where they can apply and get codes up and then it be part of the rent relief program.
Right.
Because they're then getting on the rental registry. We definitely want to encourage all the landlords to do that. So that's great. Are there other?
Sorry, I want to jump in on something that I'm going to kick myself if I don't touch on, that I meant to make a slide to remind myself and I didn't do that. I think it's important to talk about, Lori and I have both said the word tenant probably 80 million times this presentation, but I want to talk about people who might not be tenants, but still be unstably housed in the community, because there is a program set up at the county for people who do not have legal rights to an apartment, who are not a tenant, who might be couch surfing, or staying with friends or family and being asked to leave. Some of those more tenuous situations where they don't have legal rights, they won't go to eviction court, there's no formal eviction, things like that. There is a program set up through the county that tenants can call, or not tenants, that people can call who find themselves in some unstable housing situation to get help that way. And these programs are, without getting into like the full spectrum of what's homeless prevention and what's not, because rent relief is not homeless prevention and homeless prevention is not rent relief. These are homeless prevention projects. So we're really trying to prove that without this assistance, people are going to end up in emergency shelter. And anyone who currently is a tenant doesn't qualify for these programs because of the protections that are in place for tenants in terms of eviction court. So I'll throw that phone number in the chat, but really it's, if you are talking to someone who just has an unstable housing situation and you aren't sure, have them call the number because they'll walk them through what does qualify and what doesn't. And also applications that do come in through rent relief will also be screened for these projects in case someone fills it out and they say, no, I'm not a tenant, no, but explain something in the application that would make them qualify. Those will be screened at the county as well. So it's great that all of this is happening at the county so that everything can be screened there. It's you know, all one big team over there looking at this, but there is a specific phone number for people outside of the rent relief qualifications.
That's great, Megan. Is there also a website for that, or is it just the phone number?
It's just the phone number. If service providers do have questions, I'm more than happy to answer and help people navigate that too. But the folks at the county will be the ones to go through the whole process. But I'm happy to answer questions if things about eligibility for that.
Lori.
Thank you, Megan. That's an important point to bring up. And I also wanted to point out, and we're getting to the end of our time here, that people who are couch surfing or have been living with permission of the owner, or they are there as licensees, anyone who has lawfully entered the property and has been there for more than 30 days also has protection from just being, kicked out. So that there is a new provision of the RPAPL 768, which makes it illegal for anyone to engage in self-help eviction. And I think you will probably see a lot more of that in the next few months. People cannot be summarily removed by a landlord. It's always been illegal. It is now a crime. So it becomes a matter for law enforcement, and the DA's office has assured us that they will help. If people call the police and the police aren't responsive, tell the police to call the district attorney's office. They are wanting to be protecting tenants' rights, especially in the city of Syracuse. We've done quite a bit of education with them. We want everyone to know that no one can legally remove someone who's lived there lawfully for more than 30 days without a court order. And, that's why we're at court trying to prevent these things from happening too. So even if they're not tenants, those protections still apply under the RPPL. Okay.
That's great. Lori, thank you. Megan, boy, we can't tell you how much we appreciate the two of you lending your time and expertise to this discussion today. I do have, Megan, I saw you put your email in the chat. Thank you for that. We do have a slide with contact information for both Lori and Megan. And of course, you can always reach out to Nita and we can connect you with these two excellent resources as well. So I'm just going to hold that up for a moment and give everybody a chance to take that in. We do have another Financial Friday next month, but during rent relief, you've got Lori, you've got Megan, Nita. You can contact Nita for support. There are all those agencies that were listed on the Onondaga County Rent Help website that we went over earlier. There's dozens of agencies in town who are here to help people negotiate that. We are out of time, so are there any last minute questions before we sign off for the afternoon? I'm going to give a brief plug for our Syracuse Financial Empowerment Centers, which are an amazing free resource to everyone in the city of Syracuse. Yes, Meredith.
When you're done, Andrea, I just wanted to give a quick plug for my free taxes. Right now, our VITA appointments are all filled up, but for anyone who needs to file their taxes last minute, or very importantly, and we'll be talking about this more soon from the Cash Coalition, if you have no earnings and you still qualify for child tax credits, you do need to file your taxes. So myfreetaxes.com is a good resource for that as well.
That's great. And Sarah put my free taxes in the chat for us. Yes, next month we will be talking about the child tax credit. And I have to say, when I looked at the income requirements for that, they are generous. So if I had children right now, I would certainly qualify. I mean, I do, but he's 22, so that doesn't count. But if you have a child under the age of 17, you should definitely take a look at this program and see if you qualify. And we will be presenting on it on the first Friday of the month in June, which is June 4th. And Nita will be sending out invitations to register for that. Again, Megan, Lori, thank you for sharing all of your thoughts and expertise. I know your time is valuable, and there are some thanks in the chat, and we look forward to working with you in the future. So thanks so much, everyone.
Thank you.
And we are going to stop recording.